we're on in the matter of Kester versus Kester, case number D073842443Z. Good morning, may I have your name, please?
Hi, my name is Dawn Perez, Greenfield.
Okay, thank you. Good morning, ma'am.
Good morning.
Do we have Mr. Kester on the blue jeans?
Yeah, I'm here.
Okay, great, thank you. Can I have you both please raise your right hand?
You and each of you do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right, thank you. Okay, we are on for Ms. Kester. I believe this is your motion. Motion to set aside the order of judgment and a default, as well as there's an opposition there too. I'm looking at your motion, so you're referring to here, basically you're stating that the representations that were made to the court were incorrect, and that there was a downward deviation of child support?
Correct, yes. So during the last court hearing, the judge asked if I have medical coverage in the motion. And my attorney failed to disclose that information, so that's why I'm back here today to let the court know that yes, the medical coverage information was in the motion.
Okay.
Yeah.
Okay, so grounds for setting aside are normally based on mistake or fraud or misrepresentations. So you're stating to me that there were misrepresentations made to the court on your behalf at the last hearing that you'd like to correct.
Absolutely,
Is that
yes.
true? Okay, so the law says that motions to set aside are freely granted in the interest of hearing cases on the true merits. So if what you're saying is correct, I will be willing to entertain that brief portion with regard to the misrepresentation. I'm not opening it back up for everything else though.
Absolutely.
Okay, all right. Okay, so I do want to go ahead and hear Mr. Kester's argument. Mr. Kester, do you have anything that you'd like to say? I am willing to entertain just brief discussion regarding the very specific medical piece and the downward deviation.
Yeah, as far as the medical goes, I currently have Medicaid for Avery and myself, and I've also had medical for me and Avery for probably the past 4 years, and she wanted me to pay for half of the family plan that she had Avery on. It was her, Avery, and my 2 other children. And she wanted me to pay half of that, which I didn't agree to that at all, because, I mean, why am I paying half for everybody else who's already an adult, including herself? Why would I be paying half? I only had to pay for Avery alone, but she insisted on half, and I just don't see how that's right, especially if I already have coverage on Avery. That just made no sense to me. I mean, I don't know what she's trying to do here. So I don't know. As far as medical goes, Avery's been covered. My side.
Okay. So, ma'am, were you required to obtain coverage for Avery with your medical?
Yes, it's been court ordered for many years that I am responsible for medical coverage for Avery, and so I've always had it. And I just have 2 things in regards to what he just said. For one, why is he applying for Medicaid when I've already been covering Avery for so many years? And then 2, how is he even eligible to have Medicaid? Because his FDF that was filed in November of 2022 states that his monthly gross income is $36,000.
36,000 or 3,600?
36,000.
Okay. So how much are you paying for, I know that sometimes with insurance it's called a family plan, so it doesn't really break it down. So your family plan, how much, I want to identify what's Avery's portion, not the family plan portion.
Okay. So I did get the breakdown. I did have that in an exhibit for you to look at.
Okay.
And so Avery's portion now is $284.20.
Okay. I apologize, I don't think it was flagged. Let me pull that up, because I do have your material here. Okay. So let's see. Oh no, this is your modification. Did you submit a separate exhibit? Because I don't see it attached here.
When I sent this for today's court hearing, I
Mhm.
just said, it was separate.
Let's
It
see,
wasn't
that's-
actually within.
Okay, let's go pull it back up then. I don't see an additional exhibit that you filed separately.
Your Honor, can I say something?
Sure.
Yeah, also, that's not correct about her having coverage on Avery the whole time. She just got coverage on him, I believe it was last year, might have been 2021.
Okay.
But other than that, she has not had coverage on Avery until then.
Here it is. Okay.
So I don't know why she was saying the whole time.
Sir, are you
I do
making
have-
$36,000 a month?
No,
What's
that's
your
incorrect.
What's your gross monthly income?
Honestly, right now, probably for the month,
Oh, it's
probably making maybe 500. I do own a company, trucking company. I'm completely upside down in it. Probably about almost $500,000 in debt, my trucking company. So, I mean, yeah, I did have an okay year last year, but it's completely changed since then. Been bad. And, I'm struggling right now. And Don hasn't been paying child support at all. I'm fighting with the DA. She owes over $20,000 in arrears. Last I checked was a felony. And the DA is confused. They dropped it. They basically erased all my arrears, and they're trying to say she only owes $5,000 now. They're doing an investigation currently to figure it all out.
It's been confirmed.
But at the end of the day, Your Honor, she hasn't paid child support. She's been making this a whole, this whole thing just been a pain. I'm actually about $50,000 in debt with attorney fees because of her dragging me to court twice a year, every year. None of them was 20% change of circumstance, except for when she quit her job, and she refuses to pay child support. Period. I mean, I don't understand how I keep getting dragged to court for all this nonsense, wasting my time and all this stuff every year. She does it twice a year. Doesn't pay child support. He hasn't had coverage on Avery until recently. I mean, she hasn't done nothing as a parent. And, it's all there, documented. And I just don't understand why this keeps happening.
Okay.
They,
Thank you,
they
sir.
don't,
That's good enough, sir. Thank you. So, ma'am, I'm looking at your exhibit, and I see your sticky note that says Avery per monthly premium $284.20, but I look to the table next to it, and I don't see where that supports what your sticky note. I can't take your sticky note. That's just your handwriting. I'm looking for actual breakdown.
Okay, so on the top left, in the little box, it says per hour. And then you go down to health and welfare.
Yes.
And then you go to the right where it says $8.20 per hour
Yes.
for a 40-hour week. And that's how it works with this breakdown.
Okay, so if I calculate $8.20 an hour for a 40-hour week, what does that mean? These
That
are
is
just
how
numbers.
much is taken out of the health and welfare for the insurance coverage for the family.
Okay, so that's $328. That's $8.20 times 40 hours is $328. And that's for the family. Who's covered in the family plan?
5 people.
Okay.
Me, my husband, and my 3 kids.
So 328 divided by 5, if they don't give you a breakdown, then that's 6560, which is Avery's portion then. Based upon your testimony herein that you provided to me, I'm going to trust your representations that health and welfare was moving that over to $8.20 multiplied by a 40-hour week. That's $328. Divide that by 5 people in your family, comes out to 6560 will be your downward adjustment.
For the month? Because it's for each hour for the whole month.
Okay.
That's how it works.
Okay, so 40 hours a week. So what you're saying then is $8.20 is deducted from your pay for every hour for the
It is
whole
worked
month?
for the whole month.
Okay, so that's
Yes.
times 40 hours a week is 328 times 4, so that's 1312 divided by 5.
Yes.
Okay, then that would be 262.40.
Okay, yes.
So the court will go ahead and find that the motion to set aside relief based upon misrepresentations provided to the court regarding the medical insurance that the plaintiff is paying, the court does find good cause to set the prior order aside, very specifically only this pertinent language pertaining to the downward deviation for medical insurance. The court finds that all other language in the order that was filed on December 19, 2022 shall remain. Ma'am, did you identify the specific language in that order?
I did, yes.
I mean, the page number, sorry.
Page 4,
Okay.
starting on line 15.
Okay, let's go ahead and make those adjustments right now.
And then just, that was before the new insurance came into effect on January 2022.
Page 4, line 15 just says the motion to modify is denied. I thought there was something here that has the breakdown of how much your child
Oh.
support.
From my original motion,
I
not
need
the last, court order from November.
I'm looking for the order that says what your child support amount is.
Oh, sorry. Yes, I have it here.
So,
Recent order is on, child support is on page 4, and it's on line 6.
it's not there. Oh, sorry, you're right. Okay, so here it just says, inquired as to the amount of child support, ruled the order ambiguous. Court inquired as to why, after the court advised that never such an order would be in effect, which determined child support to be $517 a month, and the $50 a month would be paid towards arrearages. There's nothing here that talks about medical. So there's nothing here to set aside.
Because the medical on my motion that day for, the motion for November 8th is that original motion, where it stated in that motion for that court hearing
Okay.
on.
Well, I'm challenged because I'm looking at an order to change the language so that I can include this new language, but I don't see an order that actually has the language regarding your medical.
Because that's why,
It was never
it
talked
was
about?
it was misrepresented that day. It wasn't even mentioned because she had
Okay.
asked, and then everybody said, oh, no, it's not in there.
Okay, I'll just make an addendum, a new order today. All prior orders will remain in effect. I'm not changing the prior orders. The only change that I'm making today is that the court notes that the child support amount of $517 per month will receive a downward deviation of half of $262.40. So $262.40 divided by 2 is $131.20. So 517 minus 131 is 386.
386.
So the court does find that based upon the testimony of the plaintiff and plaintiff's demonstration that she is receiving a deduction of $8.20 for every hour that she works, which is 40 hours a week, 4 weeks per month. The court
Your Honor, she
concludes
doesn't
that-
even work.
You don't work 40 hours a week?
Does not work.
Husband.
Oh, this is your husband that works.
Yes.
I don't understand how she can get a deduction when she doesn't even pay child support. She owes me $20,000 in arrears.
I am paying
Well,
child support.
Child
monthly.
support is calculated by the 517, but there is a downward deviation for if a parent is paying for the health insurance of the child. And there is, of course, a policy and preference for kids to not be on public support if there's a parent that's ready, willing, and able to put them on medical insurance. We don't want to bombard the state with Medicaid and have all of our children on Medicaid if there is medical insurance that's available.
That makes sense. Well, can I have a question for Your Honor? Is there any way, I'm sick and tired of this. So basically what I'm asking you or the court is, can I just not have her pay child support no more? No contact, just be done with her. Avery sees her whenever he wants to. And if she just pay me my arrears in full, no payments, we can just be done with this whole thing because I just don't want to keep coming to court, and I keep, I'm the victim here.
Well, sir,
I mean,
the
this,
two of you can negotiate out of court. I'm not
mm,
going to.
mm,
I
that's
because of if Avery was well provided for and there was no need for support, then I would be inclined to do that. But I have to help you understand that you waiving child support is not in the best interest of Avery right now. If he's
doesn't
on
even pay though.
if he's on
That's
public
my point.
assistance, well, that's where you get enforcement. You go through the office of the district attorney and you get her to enforce, or you can file an order to show cause. Ma'am, I can show if he files an order to show cause to hold you in contempt of court for failing to pay child support, you can be sanctioned with jail time.
I am paying child support,
Okay.
and I have proof on it.
Okay, so you need to continue to pay. I'm not gonna find it's in the best interest of Avery for child support to be waived at this time because she is responsible for paying his child support. She needs to pay it. You're obligated by law to pay it. If you fail to pay it, you can be put in jail. But right now, because Avery is on public assistance by Dad's own testimony, I can't take this child off child support and make him now a burden on, necessary.
She doesn't pay.
Especially, sir, if you're telling me that you're $500 under, you're $500,000 in debt. So I can't make Avery put him in a place where now I'm gonna tell Mom, you don't have to pay child support. By the way, Dad's $500,000 in debt and he's on Medicaid. I can't do that. That's not in the best interest of the child.
But-
He deserves to receive child support.
But
So,
Your Honor,
at this
I
point,
mean-
it's denied, sir. Your request is denied. So at this point,
Right.
I'm going to go ahead and, I'm contemplating though this adjustment though, the $517 a month. If you're already in arrears, this will be moving forward for any adjustments, but you still need to make the payments on any and all arrears. From today, for the month of effective July 1st, I will adjust child support to be with a downward adjustment from $517. It's going to be deducted down to $131. So $517 minus $131 is $386.
386.
As of July 1st, your your adjusted child support amount will be $386. However, that's not to say that you're still responsible for any and all arrears. I don't wanna have to see that you're not providing for Avery.
I have
Your son
full
deserves, and he's entitled to have support, so I need you to make sure that you're making good on all your payments. But as of July 1st, the court's granting your motion. You're responsible, ma'am, for creating this order from today. The court grants the motion, to clarify, is what I'm doing. I'm not setting aside a prior order, cause I'm looking at the order and nothing really says anything that contradicts you. So I'm just I'm granting your motion to clarify a prior order of the court. And the court is specifically looking at the order dated December 19, 2022. On page 4, line 6 through 8, the court is going to adjust the language to say that child support to be, I will strike the words 517 and replace 517 with 386 a month, effective July 1st, 2023. I'm going to strike the words $50 a month towards arrears, and I'm gonna increase that to $100 a month towards arrears. And I'm going to add those sentences at the very end. Plaintiff's 517 child support obligation receives a $131 downward deviation for payment of Avery's medical insurance. So again, the next sentence will be added, says plaintiff's $517 a month child support obligation will receive a $131 downward deviation for payment of Avery's medical insurance, thereby resulting in an adjusted child support obligation as of July 1st, 2023, in amount of $386.
Okay.
Okay, and actually I'm going to remove, you know how I said to interlineate 517? Don't interlineate that, leave that there, so it shows history. So the language will now say, which determined child support to be $517 a month we're gonna keep that there. And we're gonna keep the prior language and a $50 a month payment towards arrears. We're going to keep that language because it's important for the court to see the history of why we went from 517 to 386. So I'm not going to strike any of that language. We're just gonna add an extra sentence, 'cause that's why it's a clarification, and we're going to say that plaintiff's $517 a month child support obligation will receive a downward deviation of $131 for payment of Avery's medical insurance, thereby resulting in an adjusted child support payment of $386. Okay?
Okay.
Your Honor, real quick, can you repeat to me what it was I can do for her to possibly do jail time for not paying child support?
You would have to go to the self-help center, sir, and the only way I can entertain that is if I have an order to show cause in front of me. So you would have to file an order to show cause to hold her in contempt of court for failing to pay child support. Okay?
Okay.
So go to the
Thank you so
self-help
much.
center and they can assist you with that.
Gotcha.
Okay.
I appreciate it. Thank you.
Okay, you're welcome. Okay, so these are the final orders of the court. I just added that sentence. It'll be added. I'm not gonna remove the 517 and $50. Let's keep that there. Just keep the new language, okay?
Okay.
So ma'am, you're responsible for creating this order.
Okay, so that would be through the self-help
Yes,
center
you can
too?
go to the self-help center.
Okay.
You're gonna get a copy of these minutes and
Okay.
basically take everything that I said, which is where I said the findings. You don't need all the language, but just the court finds. And then the court finds it's in the best interest of Avery for his child support to be adjusted to reflect the downward deviation of $131 as in for plaintiff's payment of his health insurance. This adjusted amount of $386 will be due and owing effective July 1st, 2023. All prior arrearages are due and owing, and that's gonna be in all caps. Any and all arrearages are due and owing, okay? You still must pay those arrears through the office of the district attorney, okay?
Okay.
All right, so ma'am, you need to prepare the order, and then send that over to me, and sir, if you wanna file an order to show cause, you can file that as well, okay? All right.
Okay.
Thank
Thank
you
you.
all.